new Black Panther Party stated that they were going to have 300 poll watchers across America. We are unaware of any incident that occurred anywhere beside Philadelphia. So the evidence in that particular context demonstrated or suggested that if there was indeed a national conspiracy to intimidate voters, that there would have been, it stands to reason, activity elsewhere. So as it related to the National Party and the national president, and again, the evidence showed that shortly after the election, the National Party disavowed the activities and actions of the two people acting locally, and so that judgment was made not to seek that the evidence did not support the actions against the National Party and the national chairman.
Right, but I'm asking.
Then once you have that happening, you are in a situation where you can no longer, because of the narrow tailoring requirements for the injunctive relief.
But you're not answering my question.
No, I actually answer, because you're asking the question of why did we make the decision that we made.
No, that's not what I asked. I said who or why did someone overrule or
and I'm explaining,
Ms. Flynn's determination?
Because they took a look at the evidence, and this.
And didn't Ms. Flynn also take a look at the evidence?
Mr. Blackwood, I've worked at the department under Republican and Democratic leadership, and I've been involved in many, many cases where you look at evidence, and reasonable people of good faith can take a look at evidence and draw different conclusions from the evidence. This is a case about career people disagreeing with career people. That happens very often. I've had many cases when I was a prosecutor where I looked at a set of facts and I concluded that we should go in one direction. My supervisors reviewed it, and they had much more experience than I did, and they concluded that we should go in a different direction. That kind of robust interaction is part of the daily fabric of the Department of Justice, and that's precisely what happened in this case.
Well, just so we're all clear, though, when you say career people overruled career people, in this particular case, if we could see slide 3, there was a total of 6 career attorneys that said the matter should proceed.
No.
Now, that's fine. Mr. Rosenbaum and Ms. King came to a different conclusion. But it is, I would think you would agree, slightly unusual that in a case where it's in a default posture, literally the other side has conceded liability and the only question is what is the relief or the remedy, that in that circumstances, the 6 career attorneys are overruled by 2 other.
We have a continuing duty, whether it's in a default posture, whether it's a pro se defendant, whether it's the biggest white shoe law firm in town representing the defendant. Our obligation stays the same, which is that we continue to have a legal and ethical obligation to ensure that we can present evidence, that there's sufficient evidence to sustain the elements of the particular charge. In this case, the conclusion was made that as to the defendant who had the nightstick, that there was indeed sufficient evidence to sustain the charge, and so the default judgment was sought and obtained as it related to him.
Okay.
As it related to the other defendants in the case, Ms. King and Mr. Rosenbaum concluded that the evidence did not support that, and that was the decision that they made.
Okay, this goes back to my original question, though. Of the 8 career attorneys looking at it, the 6 I mentioned, and then Ms. King and Mr. Rosenbaum, they're all looking at the same evidence, correct? I mean, there's no new additional evidence that was collected after January 7th.
Correct. People can look at the same set of facts, just as in the other cases I provided. People can look at Minutemen brandishing a weapon at a polling place in Arizona during an election and conclude that that sounds intimidating.
Okay.
The division concluded that it didn't meet the high bar of Section 11B.
Okay.
And so that is, again, reasonable people can look at the same set of facts and reach different conclusions. Career people can disagree with career people, and that's precisely what happened in this case.
Okay, Vice Chair Thernstrom.
Thank you very much for
Morning.
appearing. I'm interested in 3 things you have talked about. One, I didn't know that there had been, and I'm extremely interested. You had first thought that there was a threat of a national conspiracy, as it were, 300 incidents, 300 poll workers, whatever the description was. And it's one of the arguments I've been making from the beginning here at the Commission, is that this was a one-off, and therefore I would have been very interested in having a briefing, but I didn't think it merited the statutory report. But and I just want to say that, to me, that is an extremely important fact, that you had expected, something on a much larger scale, and it didn't occur. I'm interested in answers to two questions. One, you have talked about the confidentiality interests of the department, and I wondered if you would spell those out. I'm concerned about those, whether it's a Republican administration or a Democratic administration. And two, I wonder if you would spell out, you said that the standard for the burden of proof in 11B cases is very high, and I'd like you to spell out what that standard is. I might mention that I'm the only person on this commission who is not an attorney, but a political scientist. But I have written two.
Play one on TV, though.
But I have written 2 books on the Voting Rights Act, and neither one did I talk about 11B because it's been such a minor provision.
Sure. You asked some very good questions, and let me attempt to address them. The confidentiality interests in not disclosing internal deliberations have been a time-honored interest throughout Republican and Democratic administrations. We have many cases in many different areas that we investigate in the Department of Justice. And the goal that I have, whether it's voting, whether it's criminal, whether it's education, is to foster a robust dialogue. And one way that is a critical way to foster that robust dialogue is for people in the front lines to appreciate that they can offer me or whomever, Republican or Democrat, as the Assistant Attorney General, that honest and candid advice, not having to constantly wonder whether, if I express this opinion today, will it show up in a PowerPoint presentation tomorrow? And this has been a tradition that has been throughout Republican and Democratic administrations. I recall vividly when I was a career attorney under John Dunn, the Republicans.
I know him well.
Yes,
Remember him
and
well.
he's a man of great integrity,
Right.
for whom I have great respect. This is an interest that has been expressed and put in practice. We also have great respect for the role of Congress, the role of this commission. I'm here today because I have great respect for the institution of the Civil Rights Commission and the role that it has played in a host of issues. And that is why we provided over 4,000 pages of documents, including interviews, et cetera. And when we have this back and forth with Congress, we do very similar things. And our interest, again, is ensuring that those confidentiality interests in our internal deliberations are indeed protected, while simultaneously balancing the work that you appropriately have and Congress appropriately has. And we've, I think, historically been able to work those out. And that's why, as the head of the division, I come here today to talk about the matter. 11B, you're correct. If you look at a pie chart under Republican or Democratic administrations, it's been an infinitesimally small part of the enforcement since 1965. We could only find 3 cases that the department brought. One was the Harvey Gantt, Jesse Helms case, which resulted in a settlement. And the other 2 contested cases were not sustained at trial. One was long ago and one was more recent. And I outlined those other cases where there are facts that arguably demonstrate intimidation, where, again, the case wasn't even pursued to begin with. And so the courts have set a high bar. That is the hand we're dealt, and I think that's a big part of the reason why we proceed as such.
Thank you, Mr. Perez. Commissioner Gaziano.
And I have 7 minutes yielded time
Yes,
from you, 2 from you, and
I'm yielding 2 of my precious minutes to Commissioner
We're
Gaziano.
going out of seniority. Is this basically what's going on now?